An executor is the person or organisation that you choose to manage your affairs after you've passed away. In essence, their role is to ensure that the wishes that you've described in your will are respected and acted upon. At a minimum, those sorts of wishes would include what happens to your assets, who benefits from a deceased estate, and when they receive that benefit. In some cases, it might also include your preferred funeral arrangements, information of organ donation, or an appointment of a guardian for your minor children. To properly manage your deceased estate and work through your wishes, there are a number of important tasks an executor must perform, and two of these need to happen straight away. First, an executor needs to find the original will that appoints them. This might sound a little obvious, but Victorian law has some quite strict definitions as to what a will is or is not. A photocopy of a will, for example, is unlikely to be sufficient in the eyes of the law and is going to create administrative and legal headaches later down the track. Second, an executor has a responsibility to ensure that the funeral is arranged. Practically speaking, the executor's role isn't to wade in and override family preferences, but because they have your will, they'll be able to communicate your wishes. If there is no family or people can't agree, an executor usually steps in and signs the necessary paperwork with the funeral director and cemetery. Once those immediate tasks are taken care of, the executor needs to obtain formal legal authority to administer your affairs. This is referred to as a grant of probate, and is essentially the Supreme Court's confirmation that the executor has the right to manage your affairs. To obtain a grant, the executor will need to make an application to the Supreme Court that includes your original will, along with a death certificate, inventories of your assets and liabilities, and various affidavits or supporting material. Obtaining this grant of probate is a critical step, as your executor will now be able to instruct financial institutions to sell up or transfer your assets onto their new owners. An executor with a will but no grant of probate isn't likely to get very far if they try to transfer shares out of your name, change the name on a property title, or withdraw money from your bank account. An executor's role isn't all about transferring money to beneficiaries though. Paying debts is the key part of the job. Even if you're diligent in keeping your affairs up to date, there will always be a handful of bills that need to be paid. Utility accounts, mortgages and credit cards all need to be settled before beneficiaries can receive their entitlements. There are also the costs of managing the estate and its assets to take into consideration. There are probate lodgement fees, for example, not to mention the cost of cleaning the property, keeping insurance up to date, and paying a conveyancer to sell or transfer the property. An executor doesn't necessarily need to dip into their own pocket to pay these bills, but if they transfer money onto beneficiaries without paying those creditors, they do leave themselves financially exposed. The executor has a range of other responsibilities. They must keep accurate financial records about the deceased estate and should be obtaining professional advice where appropriate. The extent of this advice will depend on what the deceased estate contains. Usually they would include things like tax and financial planning advice. Through all of this, the executor needs to act impartially and be able to manage conflicts such as disputes between family members. By making someone executor, you are giving them the power to make a range of important legal and financial decisions. Make sure that the person or organisation that you nominate is going to be able to properly perform those tasks and respect your wishes.